How could South Africa safeguard Rafah, a region in Gaza that houses 1.4 million Palestinians from Israel's ground offensive? South Africa's approach was to take Israel to the International Court of Justice, ICJ, once again, and set an example this time. They believed that the ICJ would no longer tolerate Israel's acts of genocide. However, the ICJ's response was unexpected. Instead of accepting South Africa's formal request to intervene and restrain Israel from attacking Rafah, the ICJ did something astonishing. This has shocked international legal experts worldwide. On Friday, Israeli Defense Minister Yoav Gallant announced Israel's careful planning of a military offensive in Rafah, a city in the southern Gaza Strip. This has raised concerns internationally about the safety of hundreds of thousands of Palestinians seeking refuge there. It's important to note that Rafah is currently home to around 1.4 million Palestinians, which represents over half of Gaza's population. Many of them have been displaced by conflicts in the region and are living in extensive tent camps. Essentially, Palestinians from various parts of Gaza have sought shelter in Rafah, and now Israel plans to attack it. In response, President Joe Biden has urged Israel not to proceed without a credible plan to protect civilians. He has called for a focus on achieving a ceasefire and expressed optimism that it can be achieved. Biden also hopes that the Israelis will refrain from a large-scale ground invasion. Furthermore, negotiations for the release of hostages are underway, and Israeli media suggests that Prime Minister Netanyahu will brief the government on the army's strategy for assaulting Rafah next week. Egypt has warned that an offensive on Rafah could strain diplomatic relations, and many other world leaders share similar concerns. In simple terms, everyone knows that attacking Rafah would result in a massacre, as stated by the UN. However, Israel has not faced any obstacles. According to Channel 12, Netanyahu intends to present the government with a plan to attack Rafah, which involves relocating Palestinians to other regions in the Gaza Strip and preventing their migration to the northern territories. War Cabinet member Benny Gantz supports continuing the conflict, even during Ramadan, and suggests expanding operations in Rafah if Israeli captives are not released. Israel's plan to target the densely populated and secure area of Rafah, where displaced Palestinians have sought refuge, has received international criticism. Given the potential catastrophe, South Africa decided to approach the International Court of Justice, ICJ, once again accusing Israel of violating previous ICJ rulings. However, the UN's top court dismissed South Africa's request to increase legal pressure on Israel and prevent a military operation in Rafah, citing adherence to existing measures. South Africa had urgently called for steps to safeguard Rafah, as it is considered Hamas's final stronghold. In the past, South Africa filed a complaint against Israel in the ICJ, alleging violations of the Genocide Convention. While the court has yet to make a definitive ruling, it instructed Israel to protect Palestinian civilians and allow humanitarian aid on January 26. Unfortunately, the ICJ declined South Africa's primary request to halt Israel's military campaign. Currently, the ICJ emphasizes the need for immediate and effective implementation of the measures outlined on January 26, covering the entire Gaza Strip, including Rafah. The rejection of South Africa's application is based on the court's insistence that Israel must fulfill its responsibilities under the Genocide Convention and ensure the safety and security of Palestinians in Gaza. However, South Africa believes Israel will still violate the court's order by attacking Rafah. Although the ground offensive has not yet commenced, plans are already being made. Therefore, South Africa made the rational decision to approach the ICJ and obtain an order restraining Israel from attacking Rafah. Israel is currently carrying out airstrikes on Rafah, which is a clear violation of the ICJ's orders. However, South Africa's application to address this issue was rejected. Instead of accepting the application and initiating a debate, the case was halted, indicating that the ICJ was not inclined to pressure Israel. This gave Israel an opportunity to criticize South Africa, accusing it of exploiting the Genocide Convention to protect the Islamist terrorist group. In a concise document, Israel dismissed South Africa's entire application as unfounded in fact, law, and morally repugnant. Israel maintained that the situation on the ground in Gaza had not changed since the ICJ heard South Africa's genocide allegations in January. It argued against South Africa's claim of an unprecedented military offensive in Rafah on February 11th to rescue 2 Israeli hostages, asserting that it did not actually happen. Israel labeled South Africa's characterization of the operation as an outrageous distortion. Israel accused Hamas of showing contempt for the law by not complying with the ICJ's call for the immediate and unconditional release of all remaining hostages. Jerusalem further accused South Africa of using Netanyahu's statement to manipulate the court, claiming it exposed an intention to abuse the Genocide Convention. Israel argued that the conduct of the conflict is governed by international humanitarian law, over which the court has no jurisdiction in this war. Israel criticized South Africa's attempt to use provisional measures as a weapon rather than a shield, manipulating the court to protect its longtime ally Hamas, a genocidal terrorist organization, from Israel's inherent right and obligation to defend itself and pursue the release of over 130 hostages. It appears that the ICJ's outright biased response aligns with what Israel desired. When South Africa submitted the application, Israel had requested the ICJ to dismiss it, as Israel had plans to extend its offensive into the city of Rafah. In documents released by the ICJ on Thursday, Israel argued that the emergency measures issued 3 weeks ago already covered the situation of hostilities in Gaza as a whole, and thus, the South African request should be rejected. Now, after rejecting South Africa's application, the ICJ has become controversial, as it seems to be taking direct instructions from Israel. If this were not the case, South Africa's application should have been considered and given an opportunity to be heard. The next step will be the International Court of Justice holding 6 days of hearings, starting Monday, to examine the legal implications of Israel's occupation of the Palestinian territories. The court is set to address a 2022 request from the UN General Assembly for a non-binding opinion on the occupation, with 52 states presenting arguments. While Israel has typically disregarded such opinions, the ICJ's hearings and subsequent ruling could increase political pressure on its military offensive in Gaza. Despite the dismissal of South Africa's application, Israel still faces the potential for another blow in the ICJ. This is part of a Palestinian initiative to urge international legal institutions, such as the ICJ, to scrutinize Israel's actions. During a briefing with journalists, Omar Awadallah, a senior official in the Palestinian Foreign Ministry, stated that this would politically aid in advancing a two-state solution. They see the ICJ as a platform to promote their cause. This is the second time the UN General Assembly has requested an advisory opinion from the ICJ regarding the occupied Palestinian territory. In July 2004, the court ruled that Israel's separation wall in the West Bank violated international law and should be dismantled, although it remains standing today. It's important to note that the advisory opinion proceedings are separate from the genocide case South Africa filed against Israel at the World Court, alleging violations in Gaza of the 1948 Genocide Convention. The specific question posed to the court is to provide an opinion on the legal consequences of Israel's occupation, settlement, and annexation, including measures aimed at altering the demographic composition, character, and status of Jerusalem, as well as Israel's adoption of related discriminatory legislation and measures. As for whether the ICJ is working independently or under pressure, it is a matter of interpretation. Some may argue that the ICJ is trying to compensate for Israel by rejecting South Africa's application, while others may believe that the ICJ is operating independently without external influence.